Good morning. Thank you, Dr. Kavanaugh, for inviting me here. Any of you who've heard a government speaker will recognize the disclaimer down at the bottom. These are my views. They don't purport to be the views of the Department of Justice. But I do work there, and they let me come talk, so that's good. Dr. Kavanaugh covered this a little bit, but what is a certificate of need? It's a permit issued by a state government, a regulatory authority usually, that allows a new healthcare service or facility, here's the important part, upon a showing of an unmet need. It is permission by the state to compete. So this is different than almost any other sector of the economy where if you want to compete, you just start. You're an entrepreneur, you start a business, you start competing. With a major healthcare facility, depending on state by state, you need the state's permission to start competing, and you have to make a demonstration of an unmet need. So that's what a CON is. Why does the Antitrust Division, where I work, care about CONs? Antitrust law is a broad-based law that regulates competition. The fundamental premise of the law is that competition produces consumer welfare and that artificial restrictions on competition and on the competitive process itself reduce consumer welfare. So that's the premise of the law. And in my view, it's true. So artificial restrictions on competition limit consumer welfare. That's what antitrust law is about. Why I'm here is that certificates of need are all about limiting competition. That's what they do. That's their purpose. What are the agencies? That's the FTC as well, shares jurisdiction over civil antitrust. What is the expertise in healthcare? What is my basis for coming here and telling you anything, sharing my thoughts on anything? For those who are interested, we did in 2004 a joint agency report called A Dose of Competition. It's available on both our websites, although to be honest, the FTC's website's a little easier to use and find than ours. Ours is justice.gov/ATR. The FTC is ftc.gov. This is weeks' based of hearings and testimony from lots of panelists, lots of experts, collected the views and summarized them in a report. It's about that thick, which you can download, read online, or print out. Most of what we do is not talking, but it's casework. So we bring cases, we enforce the law. That's most of what the agencies spend their time doing. The DOJ, we've got jurisdiction over health plans. So anytime there's a health plan merger of a certain size, we'll investigate it. Recent cases, when United bought Pacificare, we sued them and required some divestitures. When United bought Sierra Health in Nevada, we sued over that and required divestitures there as well. Physician price fixing, boycotts are still quite prevalent. So we've each got cases, usually investigations going on there. The FTC's got jurisdiction over pharmaceuticals. Reverse payments is a very big issue for them. It's when branded drug manufacturers pay the generics to stay out to settle patent suits. But we also, this competition advocacy is an important part of our work. So when states ask, we provide advice on how competition can improve healthcare in their particular states, and CONs are an obvious place to start. Dr. Kavanaugh listed the states that we've been active in the last year or three. They've asked for our views, and we've provided them. We also provide advice for CMS and HHS when they're writing rules. For instance, on the durable medical equipment rule, CMS asked for our input when they're drafting the rule as to how to implement competitive bidding. So what are our views on CONs? I hope it's not a mystery at this point. We don't like them. We think that they're bad. They create barriers to entry and expansion to the detriment of the competitive process that hurts consumers. CONs undercut consumer choice. They stifle innovation. They weaken the market's ability to contain healthcare costs. This is a big thing in Washington now, how to bend the cost curve down. CONs, work, in my view, contrary to that. And here's what I think of as the most, not the most important, but an important component that sometimes gets overlooked on CONs. They reduce the pressure on the incumbents to improve service. So that's what competition does. Not only has in the static sense, improves prices for consumers by head-to-head competition, which is what most people think of, but it creates an incentive to improve if you're the one who's being competed against. So the premise for my argument that CONs are bad and that states will advise that they be repealed or curtailed. Market forces tend to improve quality, lower cost, drive innovation. That's what they do. That's by nature what happens when you get competition. Examples in healthcare, which again is very heavily regulated. Competition doesn't work the same here as it does other places, but examples in healthcare, ambulatory surgical centers. They increase consumer choice, shorten wait times, lower co-insurance. But what they also do is they force improvements in the traditional acute care hospitals. So they feel pressure to improve in the ways that ambulatory surgical centers are hurting them. That's good. It's good for consumers when they do that. There's many other examples, LASIK, outpatient surgery centers, freestanding orthopedic surgery centers. There's lots and lots of examples. So when I give this talk, or even when we're investigating, the first thing that folks come in and tell me is, you don't understand, healthcare is different. This is not steel, this is not aluminum, this is not cars, this is not like anything else. You don't really understand how the market works, and market forces don't really apply. It's too heavily regulated. You should just do us all a favor and leave. That's, just so you don't feel special, that's what everybody tells me when I start investigating them. Please, just go away. So the argument that healthcare is different is, as a legal matter, wrong. It's been tried and rejected by the courts. The same argument has been rejected for doctors, it's been rejected for engineers, all sorts of professionals. The engineers in particular said, if we do competitive bidding for projects, bridges will fall down and people will die. And Supreme Court just gave them the back of the hand. That's wrong. Congress said competitive process is what's supposed to obtain everywhere unless there's an exemption. So that's incorrect. It is correct that each market is different in its own way, and that you have to take into account how the market's different. How, for instance, a heavily regulated market like healthcare will perform under competition, and that's of course true. So, what are the original reasons for CONs, or do those still obtain? Where do they come from? Well, they came out of encouragement from the federal government. Passed a law in 1974, the National Health Planning and Resources Development Act, never a short name for a law, always a long one. The reimbursement mechanism for the law in the mid-70s was cost plus. So build a facility, we will pay you for it, plus a little bit. So obviously the incentive for that is to overinvest. If the federal government's going to pay for my shiny new machine, plus give me a little bit, I'll just build it. So the CONs were encouraged by the federal government for the states to implement as a way to tamp down the incentive for overinvestment. Sort of theoretically, I guess, maybe that's true. I think the evidence is it didn't work. CONs failed in their intended purpose of controlling costs. On top of that, the law was repealed in '86. So it's no longer a cost-plus reimbursement mechanism. Typical now is negotiation between payers, typically health insurance companies or Medicare, Medicaid, and the providers. So the cost-plus mechanism is no longer there. So the original reason for CONs are gone. So I give this talk, and folks say, well, that's fine. That's no longer there, but we still need them. We still need CONs for various reasons, and let's talk about those. The most prevalent one, and I think this is put forth in good faith by dominant hospitals, but they say they're needed as a tool to cross-subsidize care. If the acute care hospital needs the extra revenues, the market power, the ability to raise their prices about what it would be on a competitive level if competition existed, they would need to be able to raise their prices in order to fund charity care, emergency rooms, the list goes on, all very worthwhile goals. They say, you know, we need the CONs, leave us alone. Without the CONs, we can't do this stuff. You know, stop and ask yourself what that really means. You're effectively taxing healthcare consumers who want the lower cost service, who want the more convenient service, in order to achieve a social goal. My argument is those social goals are worthwhile, but there's probably a more efficient way to fund them. So through direct subsidy, if you want a 24-hour emergency care, rather than through giving the acute care hospital market power, making other people pay more, so you can fund this, so you can fund an emergency room or whatever it is. Also ask yourself, does it work? What are they using the extra money for? Is it actually going to charity care and emergency rooms? You know, the evidence on that, I'm not sure that it's accurate. Obviously, it's going to be different in different cases, but it's worth examining the argument with evidence. It's the nice thing about talking to doctors and healthcare professionals who are used to dealing in evidence, right? See if it actually works. The final point, and this is, you know, getting back to what I said earlier, the CONs as a cross-subsidization remove the incentive for the acute care hospital to improve. If you give them the CON, you give them the market power, they don't have to worry about competition. Why improve? They do it out of altruism. Most market processes, businesses improve because they have to, because competition forces them to. I think, you know, nonprofits behave in the same way. Next argument in favor of CON. CONs facilitate health and safety regulatory functions of the state government. Nobody's arguing that the state government shouldn't regulate health and safety, licensure requirements, all the rest of it. Same response. Those were traditional functions of the state that were being done before CONs were implemented. They're being done parallel to CONs. CONs are not a reason for health and safety regulation. It may be true that it aids in that process, but it's not necessary. So there's probably a more direct and efficient way to achieve those goals and let competition provide the benefits to consumers that it's able to do. You know, as a backup to this, Congress set the goal. Congress said the Sherman Act, the antitrust laws, apply to everything unless there's an exemption. Competition in healthcare is good. That's a congressional policy. That's what should be going on. And as not a legal constraint on the states, but as a policy consideration, I think that's important. So what's wrong with CONs besides the fact that they, you know, limit competition? They can be abused, and they often are abused. So who would care if somebody was applying for a CON? Well, most of who cares is who's going to lose, the incumbent hospital with market power or provider with market power. So what do? Typically, they do whatever they can to exploit the regulatory process for purposes of delay to thwart entry and protect the market power. So if they can delay the entry by, say, 2-3 years by binding it up through a CON process and then appeals in courts, that's an extra 2 or 3 years of the extra revenues that they would get. There's a high-profile case going on now out near where I live in Northern Virginia, where the dominant hospital system, Inova, is thwarting entry by HCA very effectively. They've been, you know, filing appeal after appeal, zoning regulations, anything they can think of, and you know, these are folks with a substantial amount of market power, very high market share in Northern Virginia. Eventually, I think that they settled it, and you know, HCA is going to put their hospital in a much less convenient place where it'll offer less competition. But that's what happens. The example I'd like to bring to your attention is one where I wrote a letter at the request of the state Senate president in Michigan about their CON process. There had been an application for a new freestanding center for proton beam therapy as radiation oncology center. I'm not a physician, I'm not an expert on this, but what was in the literature, what was shown to me was that this was a potentially superior way of treating certain types of cancer or for certain types of patients. It was vigorously protested by the incumbent traditional photon beam radiation oncologists and oncology centers, and they fought it. Unfortunately for them, the proton beam therapy center application would have met the standards for CON in Michigan at the time. So what they did, what the opponents did, is they attempted to get an amendment to the law to change, to keep them out, right? They didn't want the potentially superior technology coming in and thwarting their market power. Tried to get the law changed. The legislature and the governor asked for our opinion. We wrote them a letter. It's on our website. And they eventually decided not to change the law. So they got their CON. So this is really an extreme example. It's not only economics, but potentially patient care that's the difference. Again, I am not an expert in any of this. I don't know if proton beam therapy is superior or not, but I think the competitive process should play out, and that those who are expert in this at least have the choice to make for their patients. If it is superior, it could be an improvement in patient care. Again, that's on our website if you want to look through all those papers. The other way that CONs can be abused is to facilitate illegal agreements. So most of what's going on with CONs, if the state was not involved, would be illegal. Because the state's involved, and the state is the cause of the anti-competitive constraint, that's why this is competition advocacy and not law enforcement. Right? If these were private agreements, they would be illegal. Anti-competitive agreements are prohibited by Section 1 of the Sherman Act. However, the process does facilitate potentially illegal agreements. So market allocations, where competitors decide how to allocate a market between themselves without the state involved, that's illegal. If they, for instance, do that and then ask the blessing of the CON regulator, that might be getting close to the line. That might be a private agreement, not a public agreement imposed on private parties. So there's two of these cases that we brought in the last couple of years, and just happened to be in West Virginia. Don't mean to pick on West Virginia. These are the ones that we knew about, where the dominant hospital was frightened of competition from a hospital entering, and said, you stay over there, I'll stay over here. We'll split up hearts and cancer. You take cancer, I'll take hearts. We don't have to compete. They made that illegal agreement, and then they asked the state to bless it. State didn't have the authority to do that. That's not what the CON statute in West Virginia said they could do. And we sued over that. We got an injunction. There's a few other examples that are on our website. But without the CON process, this sort of thing is just flatly illegal. And I think the folks who actually entered into these agreements, because the CON process is there, didn't actually know what they were doing was wrong, was illegal. CON process provides the forum to facilitate potentially illegal agreements. I know Dr. Kavanaugh said this is not a question and answer session. I don't know how we're doing on time, but I think we've got a few minutes for questions if anybody has any.
About how many states still have CON and how many states have abolished it, roughly?
Right, so the question is how many states still have CONs and how many have abolished it? I don't know the answer. I think it's something like a dozen, 15 states still have CONs. Not sure about that.
What is that website?
Our website is www.justice.gov/ATR, which is the abbreviation for antitrust. I don't know why.
What's to prevent providers from just going into the high cost or high revenue type services and not responding to the community's needs? And also, with not having CONs contribute to establishments being started that don't have the quality of care that perhaps some of the larger hospitals have?
Right, so for those who couldn't hear the question, second part was what's to prevent, if not for CONs, what's to prevent providers or hospitals from offering services without quality? or without high levels of quality. My answer to that is there's other ways to do that without preventing competition. So traditional licensure arrangements by states don't have to be through a CON process or bolstered by a CON process. It can be done directly. And I'm sorry, could you repeat your first part of your question?
And what's to prevent them from just going into increasing services that bring more revenue, but are not exactly what the community needs in those?
So the question is, without CONs, what's to prevent providers from just doing, let's call them the high-end or profitable services and leave the less profitable services alone? So the way you typically hear it is, do extra services for orthopedic surgeons or outpatient, stent placements or things that tend to be very high margin, and leave OBGYN services, psychiatric services, things that don't tend to pay as well. You wouldn't see entry there. So a couple answers to that. One is if CON would prevent the extra services that we're talking about, so the extra competition on the high end doesn't do anything, I think, for the extra provision of psychiatric services or OBGYN services. What it might do is have extra revenues for that facility to spend, right? If they don't have to compete, they can get, let's say, a monopoly on orthopedic services, which are profitable. So they've got some extra money. The question is, would they actually spend that on the other services that might be underprovided in the community? That's a question. I think the evidence is no, that they do what every profit maximizing institution does, which nonprofits do. They just can't distribute it to the shareholders. But if it's an unprofitable service, they don't have an extra incentive because they've got monopoly rents from one service to subsidize another. That's one. Second, I think the prevention of competition for those profitable services doesn't do anything to get you more unprofitable services. So you still, if you allow competition for the profitable services, that provides consumer benefits. It provides the incumbent hospital with the incentives to improve, but it doesn't really do anything to provide additional services where you think the community might need them. Over here.
Has there been research done on states where CON has gone away to show that the cost of care has actually been lowered because of increased competition?
All right, so the question is, have there been studies to show that the removal of CONs has actually lowered cost of care, or maybe broaden the question to improve competition? When Illinois was looking at this question about a year ago, they commissioned a study by the Lewin Group, which does a lot of consulting in healthcare, which looked at this, and I think the answer is yes. MedPAC also has done studies to look at this, and I think the answer is yes. Now, I have not actually gone and looked at the original data sources and can tell you that this is what I think based on their work, but there has been, I can point you to research that supports that idea. Over here.
I think I agree with that. I don't like CONs, but I keep thinking, what if in a community, every hospital group put up another hospital beside it? They have the need for 300 beds, but now you have 900 beds, and they start closing. What is the solution to if you have overpopulated the hospital market and you can't fill beds?
So I'm not sure I understood the first part of the question. Is that for those who didn't hear the what if a community is overpopulated with beds? I think the first part of your question had to do with who is putting the beds in. So let me maybe hypothesize something and tell me if I'm getting this wrong. What if the community sort of has a need for 1,000 beds? There's 850 existing, and somebody wants to come in and build a hospital of 500 beds. So now you've got more beds than can be supported by the community. Well, what happens when there's overcapacity in the paper industry or the steel industry?
I can see us pulling them out of it. That's the problem I'm seeing.
It creates.
We don't just let them close. We
Well,
keep them all open.
Well, that's in another way the competition gets interfered with. If there's extra capacity and those hospitals that say they were competing fought to put people in their beds, let's say they lowered their rates. That's good. Competition is good. It lowers rates. I think that you don't necessarily plan for an overbedded community, but when you see it, you do see rates going down.